Morning.
Please, Lord.
This is that.
Ought to have been listed as part heard item, my lord.
This is that part heard matter.
Yes, it is not indicated.
There is already one more part heard today. After that,
My lord. 18 or 19, my lord.
2020.
Case there is there. Case obligement.
Next.
Case there be written.
I pray for I beg S.I. Akan.
Mr.
S.I. Akan.
Mr. S.I. Akan, Learned Counsel for the petitioner, submits that the order against which the order
26
against
26
2133
of 2021.
of 2021 has already been complied with. Stop. Accordingly, he seeks complied, nothing survives, nothing.
Of the daily list, actually.
Yes.
Mr. Pathak.
Date to be fixed by the registry.
Obliged, Lordship.
Yes.
Mr. Pathak.
Date to be fixed by the registry.
Obliged, Lordship.
Next.
Your Lordship, with the
M. Sharma.
I am
Ms. M. Sharma. M. Sharma.
I am
Ms. M. Sharma. As prayed for by MS M. Kalita on behalf of M by the registry.
right, Your Lordship.
Every lordship. Other side, I beg to mention item number 29.
AB. Case diary there.
Case there is not there. I think, my lord.
On interim.
If the main arguing counsel in this matter,
No, with consent from the other side.
if the main arguing counsel in this matter,
No, with consent from the other side. List after
Coming
4
weeks.
weeks on a date to be fixed by the registry.
Your Lordship, maybe between 20 May and 24th May, 4th May.
It will be given. Next.
Clear, my lord, whether this is second earlier. Clear, my lord, whether this is second earlier. This anticipatory bail was rejected for this petitioner, my lord.
For that matter, my lord, he withdrew the matter.
You have again filed.
No, no,
Yes, Mr. Das.
8 days, my
78 days.
lord. Shafiqul Islam, my lord.
Well, due to his, my lord, I leave to your lordship.
2 families, my lord.
In the assault, any that?
J. Ali, my lord.
Really. This is an application under section 439 on 22/1/2023, registered under sections 1483. The prosecution is that 23 at around 6:38, the accused petitioner informant sustained grave injuries on the accused petitioner informant sustained grave injuries on his the petitioner alone.
Sorry to interrupt, my lord.
Yes.
Sorry to interrupt, my lord.
You get it? Do you have it? Just
My
complete
lord.
the order. Just see if the injury. Mr. J. Ali, Learned Counsel, he further submits that the petitioner belongs. Stop. He further. Stop. Witnesses have been recorded under section. Stop. Yes. That the petitioner was last in jail since last 78 days. A length of considered view that further detention of the petitioner. Court closed off.
22/1/23, yes.
23. 23. And tate কৈ দিবা, and
30.
Total, my lord, 9 accused persons, my lord. Accused number 1 is the main.
পৰখিনি 4 petitioners. You make that correction, and ultimately is arresting authority 31 আছিল নহয় 24 yes. Who is
But none appears.
considering the offence under the act, under the pocket of the decision, extra copy to in order to finishing the same to the two respondent number. Let registry intimate.
My lord,
Is that page?
FR is page 13, my lord.
Anyway, on the reopening, Mr. Das.
Question of law is involved in this. In fact, take it for final disposal.
Admitted
Even, Lord, whether in terms of section second schedule, whether income tax authority can proceed with the doesn't take place within 3 years, my lords.
Auction has to take place.
Yes. Assessment orders had been passed long back.
However, it's not
There is
there.
the record.
Anyway, 60. Section 68B.
Yes, my lord. Sorry, my lord.
Get one. Immovable property.
No sale of immovable.
Yes, 18. Yes. Yes.
Blood, it was blood I indicated to you.
Seven.
No, I have the earlier unamended.
And
amendment.
that is 20 from the end of the financial year in which the order.
Under the provisions of section 240.
What is the stated position? And as regards the time.
With your lordship.
Yes.
Did the
Yes.
So the demand become conclusive from the end of the financial corporation from the defaulter. The case one after so and so cannot initiate lordship. PRO issued some money, some more time to pay the to the correspondence from the department.
It's only applicable to those SSC
Point that the SSC did not approach to any
from the end of the financial in which order given
or case may be final in terms of the provision.
has been exhausted, then it becomes
5 of my petition, Your Lordship. Would
Mr. R. Dubey, Learned Counsel for the petitioner's stop, also has prima facie made out a case for hearing.
Can it be on 23rd, my lord?
I beg to. That is the 27 and 2023.
Ordered it.
My lord,
There has been certain anomaly. You have received your missed call for by this court by order dated 27. Now stop. List this matter on acquisition compensation.
Oh, my lord, here.
Right. Yes. Yes. What is the issue?
14 lesser. About more than. So proper demarcation is required, my lord.
They sought for demarcation for the land 2 bighas 4 kata 4. But
There is no point of keeping.
their content, but
Yes, I'm hearing you.
so at that point of time, perhaps they are saying that
It appears that the petitioner has already filed and for the deputy commissioner to dispose of this. Demarcation. Correct. SR Borwal and
2 and
Standing
3.
Council Revenue and MS. Direction to the respondent authority Kolkata revenue map Moza knock of NL within bracket bypass and land of the petitioners and made covered by DAG number 26 map Moza Nakari. Stop land covered by land was duly mutated and they possess the said land acquiring land for construction by DAG number 266 construction of the said NL Commissioner prepared the list of affected stroke further through check bearing 1 katha. Stop. In 1 bigha 3 katha 14 lech of the said land and found that there is government. Stop. The petition dated 11/3/2019. In the meantime, the husband father of the petitioners died. Thereafter, the petitioner submitted several representations for necessary steps. But the submissions made at the bar and a perusing compensation against 2 kathas of land dated 6/12/19 directed the under Nalkata Revenue Deputy Commissioner, the land has not. It further appears that has also not been. This writ petition can be disposed to the petitioner dated
9, my lord.
fresh direction. Of
6 weeks.
6 weeks from is at page 29, Mr. Ali.
I record my submission that in regard to that
Officer is to
Officer
carry
has-
out, my lord.
Huh?
Circle officer is to carry out.
Disposed of with the necessary steps for demarcation. This is 8 or 6?
6
Six.
6 weeks.
6 weeks from the date of disposed of.
Land compensation.
How
amount
much?
For, 44414.
Last time also to be fixed by the registry. It is
appeal.
before the NCLT.
Yes, your lordship.
Then why be
Yes, your lordship.
under section 248 the theory this court? For what reason? Companies Act
Yes, your lordship.
38.
Yes, your lordship.
Yes, Your Lordship. That I may prefer an appeal.
So where is
Period of 3 years, Your Lordship. But
there is also mention.
252.
Paros 3, Lordship.
1 second, I am Mr.
3, Lordship.
Yes, I am in 3 only. If a company the notice may, if satisfied the company.
A company is dissolved under section 248 may file an
So that
appeal.
here is right now it is the notice,
Lordship.
not even the order. Diori Learned Counsel for the petitioner submits that he has a
Deep, Your Lordship.
Instruction I have
no on 6 March the last let her file an affidavit 3/2024 and prays to place the
On payment of contractual bill, Your Lordship.
for the respondent finance
admitted at the level of executive,
that is not there.
not there, but you with a prayer.
So you are in direction to consider your application.
Chip non-issuance of caste certificate.
MS
One instruction, 3 weeks, Lordship,
MS
after election.
S Borwa
As
opposed list of
Highly obliged. Lordship,
Yes.
kindly pass over the matter for
Assam submits that perquisite extra copies to the office of the state. You supply the extra copies. Mr. Borthakur,
Lordship, perhaps
page 20.
24 and 25.
Borthakur, Learned Standing Council, PHE. This is a petition. He is seeking relief 27. Petitioner in connection with installation Dhubri and South Salm, the respondent various work orders
Yes.
in the writ petition for water program at various places, meeting of the said works, to the petitioner, certify the case of the petitioner that thereafter however, the outstanding of the petitioner, agreements made at the bar and have perused the materials available. Requested the office of against the subject works aforesaid, this court and authorities, more particularly respective engineer.
respondent 3, Lord.
Respondent 3, Assam, is that the correct designation? Yes. Assam. Accordance with law. Okay? Disposed of.
Much obliged.
Pending bills.
All the bills are scrutinizing, my
We have received but latest updated instructions.
7 submits that instructions have been received 23 to the effect that the claim of S. Borwa file an affidavit. What is happening?
Some part payment was.
In this case, I'm sorry, Lordship.
Yes, Mr. Goswami. Why are you sorry? Submits that the instructions called for by this.
Lordship, on
In this matter, my Lord, on behalf of the state, learned
As directed earlier, matter on
can it be on 26th of April?
26?
26.
First 22. Yes, where is it?
Three cases are there.
Yes,
22,
gone.
my Lord, yes.
3 days.
For 1 FIR. Fake gold.
Gold. This been so far petition number 1 2 of January 20.
Antecedents.
Antecedents, yes, they are heavy seal.
Thing
Racket Miller. Investigation is going on. We cannot say that.
Their statements, this is bail. Right? Justification of interrogation.
So far,
Third MS. This is an application under 3 and 4 at page 2. Who have been arrested on 2024, registered under section 120B40 on 22/1/2024. To the expected to be gold, where register number 2 and on stop. One stated that one who are running MS so and so Learned Counsel for the petitioner has been that the petition lasts 73 days. Stop. The case diary reveals that there are. I have heard the submissions made at the bar 2 and 3 was last interrogated. Stop. It further appears that the petition. Stop. Considering the length of detention and other and accordingly, bail. PJM. Yes. Next case.
Arrested and produced, forwarded on lordship.
55 days. Huh? Last interview.
And item number 24.
24.
Yes.
Arrested on
14.
Concern. Four. 14. That means before.
Tomorrow.
From Bipuri, Milord.
Then lordship offences under 7 years lordship.
No,
That
that's
was
why
not
I'm
there.
saying.
It is specific.
See, and this petitioner is already under in company.
Mal.
Up to date. Await up to
20.
Hello, level.
It is received, Milord. 20 or 10 minutes, Milord. Is there, Milord?
Petitioner not there.
Sorry.
Intimate. 28 30.
This is a mob lynching case.
4 weeks on a date to be fixed by the wait service report. And impleading to bring the incumbent Mr. M. Hussain file necessary application for 3 weeks on a date to be fixed by the registry. It's been complied. KK Nandi, Learned Counsel for the 3052 of 2020. Stop. Lied. Stop. In view of the aforesaid endorsed disposal.
Lordship.
The respondent number 1 and 2 have already appeared and
Have you filed any application to the other respondents? Who are appearing for them?
Superintendent of Police H4 of the name of
Why is the 2 lakh expression not being paid?
Down below you.
Verification.
Yes. May I read
So it
the
appears-
which I have furnished?
Yes, I am.
Yes.
It, nothing survives. Learned Counsel for the petitioner stop also heard this contempt petition Guwahati passed by this court by next para by order either the prayer of the petitioner as entitlement, comma, piece 2 lakh may be released to the petition. Certified copy of this order. Stop. Petition has been filed. Stop. She has received instructions in the 8/2023, which is that in accordance with the order of this court, comma, the petition Gracia grant. Stop. That the victim notification dated 15/11/2000 you have received.
Yes.
The petitioner has received the aforesaid amount. Stop. Accordingly, the contempt petitions.
1 week time for filing an affidavit.
You put your stand with the contempt petition for filing reply.
Yes, my lord. 1 week time may be granted.
If the so and so learned counsel for the petitioner stop. Prayer not opposed. List after 2 weeks on a day. Yes.
Lordship, my senior are two facts first.
Infractions? Why?
Because it is
2 submits that this matter may have been expired. Stop. However, consider this matter after 2 weeks on a date to be fixed by the registry.
We will file all affidavit.
Your name. File affidavit in open.
Data to the registry of this court.
How can that be? I do not understand. The office note also does not. Yes, Mr. Borwa, management. No one has. Would you take up the matter with the office or Ms. Bordle? Not because yesterday from Health Department a report. So we don't record your name today, Ms. Bordle. The Deputy Commissioner Kamrup Amingao to communicate is requested to so as 2 weeks on a date to be fixed by the registry.
24.
Service not complete.
For number 2, my lord, service is not complete.
Yes. For 1 6 3 weeks
Number 2.
is not complete. It further appears that
4 weeks, your lordship, because delay has incurred.
MS list this matter after so and so. Some correction is required.
Lordship. This will be stands closed with the direction to the bishop to appear.
Absolutely.
Lordship, Bilashi Para, Learned SDGM.
Counsel for the petitioner stop also heard Mr. Dida 11/3/2024 passed instead Lasipara district Dhubri Assam stop before which the petitioner has been Mayapuri instead of the correct at the order dated court of SDGM Bilasi from today.
Because it is sub.
Today is
58 days.
earlier this court has considered.
I have also an
Page.
His father's.
Yes. Change of circumstances.
Third is he's pursuing Bachelor of Social Education, going to be held on 18 onwards, my lord. Page number
Of the petitioner, the bail was rejected. There was no materials adverse at that stage. So adverse material. APP Assam for the state respondent. Stop. This is an app of 2024. Registered under section is that on 12/2/24 an FIR was on behalf of his owner and went for the goal articles. And accordingly a case was order dated 21 application. And languishing in jail since last 50. She further submits that the petitioner
29, his Bachelor.
Where is it mentioned? BSW, but what is the full form? Force and incorrect.
April.
18th
18th April to
only opposes the prayer of bail. Stop. He submits. Stop. I have heard these learned and that the case. This court is of the consideration. Court of. Yes, Mr. Mahajan. Everything same.
Everything same, my lord.
Here he was arrested on 41.
Actually, he was engaged by one lord. He was engaged by one Rahul Pawar.
It appears from Power had engaged the petitioner.
Rahul Pawar.
And
Yes, Mr.
They filed an application before this court. We sought permission and your lordship wanted
item number
40.
This is that matter.
Yes, a wildlife protection violation. An SOP has been issued.
Respondent,
Comment is there.
you filed an application.
We filed two applications. One application IA that Bulbul.
Where is that
filed.
IA? IA 1107.
Yes, 1107. This matter regarding about there are two writ petitions which was filed. The first writ petition was taken up by this court. It's
What is the relief you are seeking in this IA 1107?
What I am saying, the SOP issued by the state government in contravention with the Article 254. That's our
What
case.
is the relief that you are seeking, Mr. Das?
Yes, we claiming with the SOP which is issued by the state government. If your lordship kindly
Followed
see,
in its
see the
spirit.
Yes, I'm sorry.
That the order
Yes.
that you are seeking.
Yes. To quash the notification dated 27/12/2023, issued by the government at page 35.
What is the prayer in the petition?
That's the prayer. Page 35 is the prayer.
In the IA.
Oh, IA, we have made a prayer.
For restraining conducting of these fights.
Yes.
And in the main prayer,
For quashing of the SOP 27/12/2023.
what is that SOP?
SOP is standard operation. That's your lordship will find.
One second, Mr. Das, just one second. Quashing the notification 27/12/23 whereby these SOP has been brought in.
Correct. Right.
And under this SOP, these fights were allowed.
Correct.
So basically, you want that these fights be stopped.
Now what has happened?
Is it correct?
Yes. What has happened, my lord? SOP indicates so far as two fights. One is the Buffalo fight.
Mr. Das, sorry, I'm interfering while you are. But if we have to grant the prayer in the IA, whether would that not amount to a final relief?
No. This is finally the quashing of the SOP.
Under
SOP
which the fight is allowed, isn't it?
fight is allowed.
Correct. Which portion of that SOP, please show it.
SOP kindly see page 38.
No, this is
38.
under page, the relevant page is 43.
38, 38 in 468. Item number 57. 57.
Oh, I have 466.
468 kindly be taken. One is your lordship is holding a brief so far as Buffalo is concerned. Next is Bulbuli fight.
So this IA is for Bulbuli fight.
Yes, that's why I'm showing 468.
1 second. Who's appearing for the respondent?
That's the state government.
You're there, Mr. Borwa? All right, page 38 is the SOP.
Yes. The following SOP guidelines to ensure buffalo and other traditional bird fights are allowed to be organized all places where it has been traditionally organized with specific provision for regulation by district administration to ensure cruelty to animals is not allowed to be inflicted. Now this is background of buffalo fight. This is a particular period was given. Kindly see, my lord, that we call Mojus, buffalo fight.
1 second.
Yes.
Because on the first day when this matter was moved,
Yes.
there were some observations,
Yes,
correct?
correct.
In paragraph 8
Right.
of that order. It is already said that government, I think, has already said that they will not permit such fights in any other period except Magh Bihu.
If you see at page 39 of the same writ petition, which your
Yes.
lordship is holding it,
Yes.
kindly see page 39 and paragraph and 3, serial number 3.
Yes.
Modules may be allowed specific time for year to be counted within 10 days,
Magh
so as
Bihu.
succeeding from 15th to 25th of January. So and so shall be allowed any time of the year except the period stated above.
So, right now the returns have not been filed, and
No,
if
correct.
we go by this, it appears that they will only allow it during 15th to 25th of January. So, what is the
What has
necessity of the interlocutory application?
No, what I am saying, this is interoperably the modules. That's the first writ petition. Second writ petition is about operating SOP of Bulbuli fights.
No, but in this order also it is mentioned for Bulbuli also Magh Bihu, because
No.
paragraph 8, kindly see para 8 of the order.
Yes.
It says set of guidelines for Bulbuli birds fight. It is evident. See para 8.
Of which order?
In the writ petition which you are arguing, 468.
468.
See the order dated 6/2/24. See paragraph 8. You wanted this court to take up this writ, isn't it?
I'm sorry?
You wanted this court to take up WPC 468.
Yes.
In 468 there is an order
Yes.
6/2/24. See paragraph 8.
Paragraph 8. Notwithstanding challenge legality and validity impure notification SOP set, which would need further examination. It is
Set of
evident.
guidelines for Bulbuli birds fight.
Yes. No, there are.
Please read that paragraph
Yes,
8.
actually, let me explain, my lord.
Oh, because this is a judicial order,
No,
therefore.
I know my judicial order. I will not go beyond judicial.
Just read that
Yes,
order.
I'll read it.
Yes.
Which would need further examination. It is evident from notification SOP set of guidelines that the state government itself has observed that no buffalo fight will be permitted any other period other than 15th to 25th January in a calendar year at any other place. Any other place.
Yes.
Therefore, this court like to observe during the pendency of this writ state governments ensure strict compliance of notification SOP and set of guidelines in respect of buffalo fight. It is further observed that
No,
if
it
any
says Bulbuli
information,
fights.
if any information,
Oh, you read it as buffalo, but it said this in respect of Bulbuli birds fight.
yes,
This is regarding buffalo.
yes,
Correct.
yes.
And it says it is further observed that if any information as regards holding of Bulbuli birds fight in violation of the SOP, petitioner will be at liberty to bring the same to the notice.
Yes, correct. Right.
Right.
Yes.
So there is an order. I'm sorry, but I'm not understanding what that you want, because there is already an order that for Bulbuli fight, the SOP is there, and if there is any violation against.
So my question is that you cannot hold a Bulbuli fight. Sorry about saying.
So that is because
that
you are challenging the validity itself.
That's why I'm
correct?
saying you cannot today. If your lordship decides, that it is absolutely in contravention with the judgment of the Supreme Court and with the Act, we still, those judgment of the Supreme Court is that there is an amendment which has been made by all other three states. You cannot, my lord, there is an Act which is made by the Parliament.
Government, why is the affidavit not being filed till now? Ms. Bordla, are you appearing in this matter? Who is appearing for government?
Actually, today I am appearing for the first time, but initially the matter was being dealt by Dipankar D. Nath.
Where is the senior government advocate?
May I be given some time?
No. What this court wants to know from the government is that are you going to have any of this fight, Bulbuli birds fight?
No, that already the notification has been passed. If your lordship goes
effect?
to the previous order, 4/3/2024 order. So here.
Saying what?
Pardon.
Saying what?
The court has already passed an order observing that during the pendency of the writ petition, the state government should ensure compliance of the SOP notification. This court thinks it's proper that the direction should be issued to the state authority to notify and intimate to the district administration competent authority the fact of passing of the order dated 6/2/2024 and to ensure strict compliance of the SOP. So this and the court order dated as discussed above. According to so this was the last order. In fact,
Mr. Das, in your IA, have you made any averment that there has been some violation of the SOP?
No, it's IA we have not. IA they have. But that's a fair.
Mr. Das, you see,
I think.
Let us have the facts clear first, subject to correction. As I understand that you have challenged the legality and validity of the SOP itself, correct? Under which the buffalo fights and the Bulbuli bird fights are allowed, subject to conditions. Am I correct? Now, in that writ petition, when it was moved, there has been an order that any such fights, if held, will have to be held in strict compliance of the SOP. And if there is any violation, then liberty was granted to the petitioner to bring it to the notice of the court. Has that been done? Is there any violation? That's a very simple question that this court is asking. If there is a violation, please point out the paragraph.
Let me give a reply to it.
No, please point out the paragraph from your application.
Mr.
Das, kindly reply to the question.
Yes, I am replying.
By the
Let
court.
me reply. I will start,
Yes.
my lord. Let me reply.
Yes.
For a moment, let us. IA is no for buffalo. What violation? What violation in the other? In that case, there is a violation even in spite of the court's order. This buffalo fight was going on. So we have stated with an application that these are the districts where buffalo fights have been held. So the court passed an order. How can you do it? Because there is a period which you have been mentioned. This period only buffalo. Then after that no buffalo fight will be held. Even we are holding it. The court has taken very seriously. The court said the government will have a strict compliance of this. How do you are holding it? Your SOP says this period. And have you taken any permission for district administration authority also? You cannot. So there was some observation which was made by this court on 4th of March 2020, 24, kindly see my lord. Strict compliance.
4-3.
4-3.
Where is that order?
4-3. Additional affidavit we filed this.
Where is that order? 4-3 order?
By my lord, kindly see 466.
4-3 order passed in 468.
466.
There is no order of 4.
Common order, my lord.
Common order.
Yes.
Which file?
My lord will kindly see 466 file.
Yes.
Additional affidavit. Which
Yes.
Lordship got it?
Yes.
Kindly see at page 270. 270.
Additional affidavit.
Yes. Additional affidavit 466.
Yes, I have it.
Yes.
Page number?
270.
There is no page number 270. Additional affidavit filed by
we have on
Khushbu Gupta.
Yes. Correct.
internal pages there, because this is these are running pages from 174,
Yes.
which ends at page 183.
Your Lordship is holding. This is file on 6/4/2024.
The last additional affidavit 3124. Additional affidavit.
Kindly, no, 6/4/2024 we filed.
64.
Yes.
That additional affidavit you had filed in
466.
Yes.
466.
So that is, but then you wanted me to take 468, item
No,
57
kindly
first.
take for a moment, if it is not inconvenient, 466.
Yes.
See, my lord, at page 270.
270.
Lordship got it? 270.
70.
That is the additional affidavit. Lordship not found.
Too many affidavits. Wait.
That's the problem.
270. Yes, I've got it.
Kindly see the order which was passed on 4/3/2024. Lordship got the order?
Yes.
If you see at
What do you
page
want to show?
270, last paragraph, be that as it may, as this court has already passed an order also during the pendency of the petition, state government shall ensure compliance with SOP notification. This court thinks proper direction should be issued to the state authority to notify and intimate through the district administrative competent authority the fact of passing of the order dated 6/2/2024 and to ensure strict compliance of the SOP and the order of the court dated 6/2/2024 as discussed herein above. Even after this, some fights are being held.
Where do we get that government?
This additional affidavit. Additional affidavits.
Additional affidavit or interlocutory application?
Additional affidavit.
Same additional affidavit?
Yes, 466 of 2000.
Yes.
Kindly see, my lord. 272, my lord. Lordship got it, my lord?
Yes.
See, my lord, 272.
Annexure B.
Yes, Annexure B, Kohli,
Yes.
that our petitioner has informed to the authorities. If you see and last paragraph, further, it has once again come to our attention, supported by evidence such as YouTube videos, that another buffalo fight was organized in Ding on 5th of March 2024. Despite the Honorable High Court's order, our correspondence regard, this occurrence represents blatant violation of specific direction of the Honorable High Court to seize all buffalo fight beyond 25th of January SOP issued by the Assam State Government.
So, despite the orders of this court, the buffalo fights have been held in a period which is otherwise not contemplated under the SOP.
That's correct. That's it.
Yes, Mr.
Now,
Borua?
you see kindly,
This
minor
is a clear
270.
violation of this court's order and the assurances given before this court. Of course, you verify the fact, but it appears that there has been a fight held on March 5, 2024. The period is only during that January, where buffalo fight otherwise, as per the SOP, is allowed. Though that SOP is put under challenge, be that as it may, but under the SOP only that period, where buffalo fight is allowed, right? But now this shows that on March 5 also, buffalo fight has been conducted.
My 274,
Yes.
274 last paragraph. On 9th also, 9th of March in Morrigaon district, 274 down below.
24th February? No.
That's not 274.
Which is the date in Morrigaon?
Morrigaon is last paragraph, if you see. 9th March.
9th March.
Yes. And Nagaon it is 5th March.
The first one that at 272 is which district?
Yes.
That is Nagaon.
Nagaon.
And 274 is Morrigaon.
Morrigaon.
Yes. Yes. Let Mr. Borua
Yes,
have
I
his
think, my lord,
instructions on this.
Let them verify it.
And if this court finds that it is correct, then of course, big consequences will follow. You may have to sumo draw contempt against the hearing officers. This cannot be allowed. There is a specific direction, not on one occasion, on two occasions.
Let them take, my lord, let them verify it. whether it is correct or not, let them come with that instruction, my lord. And IA also, they have to come with a reply, IA. I'll just trouble
Mr.
you.
Das, this is clarified, but otherwise this IA is preceded after this, or it was filed earlier?
It was filed on that day.
So the latest is this additional affidavit?
6th.
All right. I will pass one order in which I will cover all this.
Correct.
And I'll indicate that they have to... So these additional affidavit you brought in I think 466, right?
Yes, right. And separately IA filed in this case. But your lordship can cover both the case in one order. The SOP is one SOP.
Anupam, Patham WPC 466, that is item number 56. Heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. D.J. Das, Learned Counsel for the petitioner. Also heard Mr. S. Borwa, Learned Government Advocate for the respondent. Stop. First order is not 4th March. There was an order prior to that also, right? 6th of February.
6th of February 2000.
It appears from the order dated 6/2/2024, and this order is passed only in 468 or in both the petition. The 6th February is passed in both the petition.
Both the petition separately.
Appears from the order dated 6/2/2024 passed by this court that that this court had clearly observed that during the pendency of this writ petition, the state government shall ensure strict compliance of the notification SOP guidelines in respect of bulbuli birds and buffalo fights. Stop. It further appears that under the aforesaid SOP, buffalo fights are only permitted to be held.
15th of January.
Yes, that date is somewhere here, no?
Yes,
permitted to be held during Magh Bihu time, i.e. 15th January to 25th January only. Stop. It further appears from order dated 4/3/2024 that it has been clearly observed that in the case of any violation of this court's order dated 6/2/2024, liberty has been granted to the petitioner to bring the same by way of an additional affidavit. Stop. Bring the incident of such violation by way of an affidavit. Stop. The petitioner, by filing an affidavit dated 6/4/2024, has brought to the notice of the court that despite of the interim orders passed on 6/3/24,
6th February.
that first is
6th of February.
6/2/24, there are instances where buffalo fight has been organized in Dhing in Nagaon district on 5 March 2024, and in Sarubori in Morigaon district on 9 March 2024. Stop. Prima facie, it appears that there has been violation of this court's order dated 6/2/2024. Stop. However, before passing any adverse orders, this court grants opportunity to the state government to address the same within a period of 2 weeks. Within a period of 2 weeks. Stop. List this matter after 2 weeks on a date to be fixed. Do you want a fixed date? Picks up a dated draft. It is further made clear that since the legality and validity of the subject SOP is under challenge, the 10 of the state respondents is essential, and the matter, and since issue involved in the matter is grave, state respondents may take note of the seriousness of the issue involved and file their returns by the next date. Stop.
Hello, there is one more instance which is not on record, that's why I find it difficult to show 13, 14 and 17 of this April they are organizing. Kindly see. After morning we came to know the clients from Delhi, they have informed us. Kindly see the first, I am writing this so and so Morigaon, DC Morigaon address. So and so.
Mr. D. Das, Learned Senior Counsel, further draws the attention of this court to a letter dated 9 April 2024, which is sent to DC Morigaon, wherein the petitioner apprehends that another buffalo fight is going to be organized in the district of Morigaon on 13, 14 and 17 April 2024. Stop. Mr. S. Borwa, learned government advocate, is directed to intimate the District Commissioner of Morigaon District as regards the interim order passed earlier by this court on 6/2/2024 and ensure strict compliance of the same.
I have it. Yes. I have given a copy to my lawyer.
A copy of the said instruction dated so and so is kept on record and marked as X. You give a copy also to Mr. Borwa.
I have given.
And the same has also been furnished to Mr. S. Borwa to do the needful. To instruct, otherwise it will be difficult. You see, there is already an order of this court. Orders of court are not for mere formalities.
I'm deeply obliged.
All right. This is that. Ilpam, I think
yes.
The hearings almost have completed. Only
yes.
I think some affidavits we had this court had granted liberty in case you wanted to file. Anybody has filed anything?
Lordship, only 2 days back I got the complete document. Lordship, I need some accommodation on the reopening, Lordship. Basically, Lordship wanted the affidavit to bring on record those schemes and guidelines at that relevant point of time.
This is a parted matter, so kindly file it on the next date. I don't want this matter to continue in the parted for a long time. Otherwise, this court will have to release it. So file it, because since the court has already heard all the parties, everything is concluded. It's just which is that guideline which was applicable at that time, only to that effect. Yes, Mr. Fokan?
Went back. I consulted the clients also in that regard. Now, 2013 and 14, when the agreements were executed, these schemes are actually introduced by the Government of India. When the first scheme was introduced in 2013 and 14, that scheme was actually prevalent only for a year's time. Subsequently, that scheme was changed. So we were appointed under that RKVS scheme. That scheme is no more existing now. The only thing is, your Lordship
argued that.
Yes. No, but your Lordships had asked, why is that scheme not available for us to see that where were we appointed? What is the nature of the business? So ultimately I realized that the status report that we filed in our writ petition categorically takes care of all these issues that your Lordships has asked us. In fact, that is dated also. Your Lordships had asked what is the date of it. That time I couldn't point it out, your Lordships, because it was not there.
Where is it?
Yes, that I have filed as Annexure 4 to my writ petition 2746. It starts at page 77. That's the status report filed by the Government of India explaining the entire...
Page 77.
This is the status on palm oil, which includes everywhere, including northeast, south, everywhere.
77?
Yes, 77 Annexure 4 to my second writ petition. Yes.
Yes,
77
this
is
is
the
status
status.
paper on oil palm.
Yes.
Yes.
Now, this status report is filed by the Government of India.
Yes.
If your lordships would be kind enough to come to page 82.
The date is there.
No, date is at page 102. This two. Yes, 82 is where they say, on the first paragraph, 3 lines from the bottom of the first paragraph. To boost the oil palm cultivation, Government of India has implemented a special program of so-and-so under RKV with an objective to bring 60,000 hectares of palm oil cultivation for the year 2011 and 12.
Continued till March 2014.
Yes, and discontinued in 2000. So what happens here, lordships, is the moment the Government of India introduces a scheme, the old scheme is withdrawn. Nature and business remains the same. That is why the role of entrepreneurship is explained in the same document at page 85. It says how the business is to be conducted also. This is the same status report they are relying on. The date of the status report is at page 102 at the bottom. It's written very smallly. In a very minute manner, I couldn't see it. It's updated on 24/11/2016 at page 102.
24/11/2016.
Yes.
The date is there.
Yes. So that means the update is based on all this, because the schemes keep coming. There'll be one scheme now, there'll be a different scheme tomorrow, but the business module is still the same, and that is explained at page 85. What is the business and how to do it? This is uniformly across in all states, whether it is Northeast, Gujarat, wherever it is. It is applicable everywhere.
The date is there, Mr.
So this is
Chaudhary.
the date I was relying on. Rest I leave it to my learned friend if he wants to produce something, I don't know. But
Lordship, while going through the documents that I have received, it gives about the inception of the scheme and how it was directed to be done by the all states. Those things are, those sequence-wise, Lordship, I will
All
try
right,
to...
if he is wishing,
I just wanted to point out that
if it
date
brings
your
more
lordship had asked.
clarity to the matter, let him file.
Yes, no problem.
Sequence-wise, Lordship, everything I have got it.
So, B. Chaudhary, learned counsel for the respondent, seeks 1 week time to file additional affidavit as in terms of the order dated 15/3/2024. Stop. Considering that the matter has already been heard partly, as a last chance, Mr. Chaudhary is the respondent is allowed to file the said affidavit. Stop. List on
Lordship, either on 24th or 25th.
from 22nd for I think a period of 2 weeks. This court shall not be available here, but
Next available date.
we can or you file the affidavit and we can have the matter connect. Court can connect through VC on that date. Can be done.
No problem.
At least let the affidavit
Yes,
by then be filed.
Yes, substantially everything is done, so just a matter of examining that document. 20.
For 25th, any date.
24th. Extremely good.
Or you do one thing, you file it by 19th. Let us have it on the 19th or 20th. Only for filing. You have already finished.
Yes.
Because in that case, we can close
Yes,
this matter
yes.
on
The
that
lodges
date.
are not available from which date?
On 22nd. Let it be on 19th.
No problem. Yes.
Mr. Chaudhary, please file it
Yes,
on that
Lordship.
date, because otherwise it becomes very difficult.
Lordship, by 19 I can file
Matter
it.
has already been heard
If
in
Lordship
part.
wants clarity, then Lordship may fix it
Correct.
for
Yes.
another
It
day.
can be fixed, yes.
And though Mr. Fukan, I think you had handed over one-page list of dates or
Yes.
something, but if it would be of assistance if both sides can give us the arguments in writing.
Yeah, we'll give it. We'll
on the next date.
on the next date. It's grateful.
Mr. Sharma can burn some midnight oil. Yes.
Please lodge.
This is that criminal appeal.
Yes, my lord.
Yes, Mr. Das, are you ready today? Yes.
Art again.
Mr. Das, you were supposed to reply.
My lord. My lord. This is obviously, my lord, typical, my lord. 7 months pregnancy, and thereafter the child died.
Just give me the gist once.
My lord.
Mr. Counsel, just give the gist once.
Yes. My lord, what has happened in this case? One FIR was lodged 2/9/2019, and in that FIR, the first sentence of the FIR is that accused number 1 secretly keeping love relation with the informant's daughter made her pregnant 7 months.
This number.
All right, 1 second. Kalpana, to dispose the karo AB hoy. Heard Mr.
T. Sutia lawsuits.
Sutia, learned counsel for the petitioner. Stop. Also heard Mr. Didas, learned APP for the state respondent. Stop. This is an application under 438 CRPC seeking pre-arrest bail to the petitioners I, Akraul Hussain and Mainul Haq, who have been apprehending arrest in connection with Sonapur PS case number 235/2023 under section C79411134 IPC, read with section 11 ABC of Prevention of Cruelty to Animal Act 1960, read with section 13(1)/14 Assam Cattle Preservation Act 2021. Stop. Pertinent to mention that by order dated 23/11/2023, the petitioners were granted interim pre-arrest bail subject to conditions. Stop. The case diary called for is placed before this court. Stop. Mr. Didas, learned APP for the state respondent, submits that the petitioners have appeared before the investigating officer in terms of the earlier.
That I do not know. Charge sheet has been
Submits that the charge sheet has been submitted, right? CS number?
CS number 04/24/2024. Dated 29th of January 2024.
29/1/2024. Stop. In view of the aforesaid endorsement made by the learned additional APP, this anticipatory bail application stands disposed of with a direction to the petitioner. It has already appeared?
Yes, they have appeared lawsuits. Has been recorded lawsuits.
Appear before the trial court, and till then the interim bail granted so and so shall continue. Disposed of. Format to what I did. Disposed of. A copy of the instruction dated 23/24 is kept on record.
Production purpose, item 1.
Yes.
In extraordinary circumstances, we had to come to your lordships. Your lordship, my lord, earlier this was rejected by your lordships.
Rejected by this court?
Yes, yes. No, recently, my lord,
any changed circumstances, Mr. Datta?
Beg your pardon?
Any change of circumstances?
Change of circumstances in the sense, my lord, recently on 4/4/2024, he fell down, and your lordship kindly see the medical college.
Page 33 is the photo.
Page 30, my lord, 30.
Yes.
The report, the last your lordship kindly see the calvarial fracture, then scalp swelling. Then, my lord, fracture noted in occipital bone on the right side. Now, in the doctor, my lord, it was referred to surgery, but they have given only medicine, my lord, the antacid, and one is, my lord, that is antibiotic. That your lordship will find at page.
Treatment is not given to the Petitioner?
Well, he has been referred to Guwahati Medical College and Hospital.
So treatment is going on?
Treatment is going on.
They are dealing, your Lordship, kindly see page 36. This is the Pantop 40, this is antacid. And the number 2
injection.
is possibly antibiotic, my lord.
An injection or?
Injection, no, maybe it is an antibiotic, my lord, 500 ml. Now, it's a case of surgery. But there
This is
no
that land grabbing matter, Mr. Das? That
yes.
Itanagar one?
Yes. No, crime branch. Crime branch, no?
Crime branch, yes.
Crime branch 3 of 24.
But for the purpose of...
the petitioner, if I recollect, was the sub-registrar.
No, he was the LD in the sub-registrar.
He was an employee of that registrar office.
Yes. For the very limited purpose for his treatment only, my lord.
What is the stage of the investigation?
That I do not know. Today it has come for the first time. Right now, I cannot say.
Petitioner is the allegations against the petitioner was that he had helped the accused persons registering the alleged forced sale date.
Exactly.
How much time? Since when are you in jail?
More than 30 days.
30 days. Yes.
I'll produce the case there on the reopening day itself.
Which police station?
19, crime branch.
Tomorrow?
Tomorrow I can try.
PD tomorrow.
Obliged.
Also, Mr. Das, find out what is the treatment given to the petitioner and the status of his physical health.
Obliged.
2 o'clock fixed asil na.
He says that he will take whole the day. Well, all right, I have to motion, I will continue, I will come back. And my part, tomorrow I will be.
Tomorrow is the last day. I think it will.
Let us start it right thereafter.
No, he
All
can
right.
start.
Maybe on another date, your part, Mr. Mohanto. Let me hear first the petitioner. Because tomorrow is the last
Tomorrow
working
it will
day.
not be
There are
possible. Yes, I understand.
a lot of bail matters also.
My lord, before I take your lordship to the facts, I would like to first place some provisions of the Act. Competition Act.
Which Act?
Competition Act.
Appearance to Lulova. Yes, Dr. Saraf.
Lordship, can you see Section 3?
Section 3?
My lord.
Yes. Anti-competitive agreement.
My lord. Says, my lord, no enterprise or association of the enterprise or persons or association of persons shall enter into an agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on the competition within India. Thereafter, any agreement entered into in contravention of the provisions contained in subsection 1 shall be void. Any agreement entered into between enterprises or association of enterprises or persons or association of persons or between any person or enterprise or practice carried on or decision taken by any association or enterprise or association of persons, including cartels, engaged in the identical or similar trade or goods or provision of services which directly or indirectly determines purchase or sale prices. Number 2, limits or controls production, supplies, markets, technical development, investment or provision of services. Here's the market or course of production or provisions of service by way of allocation of the geographical area of the market or type of goods or services or number of customers in the market or any other similar way, directly or indirectly results in bid rigging or collusive bidding shall be presumed to have an appreciable adverse effect on the competition. After proviso, but nothing contained in the subsection shall apply to any agreement entered into by way of joint ventures if such agreement increases efficiency in production, supply, distribution, storage, acquisition or control of the goods or provisions of the services.
What does the proviso say?
Lord, that in case it is a joint venture and something below the agreement entered into for the purpose of efficiency in production, then that will not be affected.
But if the joint venture entity is performing a similar trade, is carrying on with a similar trade, that is permissible.
The joint venture, if they enter into an agreement for the purpose of the efficiency in the business start, then that will not be treated to be a bar. Now, for the purpose of the subsection, bid rigging means any agreement between enterprises or persons referred to in subsection 3 engaged in identical or similar production of trading of such goods or provision of services which has the effect of eliminating or reducing competition for bids or adversely affecting the manipulating the process of bidding. Any agreement amongst enterprises or persons of different stages or levels of the production chain in different markets in respect of the production, supply, distribution, storage, sale, prices, or trading in goods or production, including so-and-so, I'm not going to shall be an agreement in contravention of subsection 1 of such agreement causes or is likely to cause an adversarial effect on the competition in India. So, my lord, the main provision purpose is that, my lord, that there should not be an effect, adverse effect on the competition, and if the provisions of section 1, 2, 3, they are the various instances where they
adverse effect on the similar trades,
and if they say they enter into an agreement in such a way that has an adverse effect in the competition, then that will be covered by subsection 1. Last we see section 4, my lord.
Yes.
Abuse of dominant position.
Subsection?
Section 4.
Section 4.
No enterprise or group shall abuse dominant position.
What is dominant position?
Well, this is important. His own, the position is there. Yes. There shall be an abuse of the dominant position under subsection 1 if an enterprise or group directly or indirectly imposes unfair or discriminatory conditions in purchase or sale of the goods or services or prices in the purchase or sale, including predatory.
Dominant position is defined in the explanation.
My lord. Dominant position, my lord,
means a position of strength.
My lord, explanation has been given. Position of strength, that means he is holding such a position.
Enjoyed by an enterprise, yes. All right.
Condition in purchase or sale of goods or services, price in purchase or sale, including priority price of the goods or services. For the purpose of this section clause, an unfair or discriminatory condition in purchase or sale of goods or services referred to in subclause 1, unfair and discriminatory price in purchase or sale of goods, including priority price and services referred to in subclause 2 shall not include such discriminatory conditions or prices which may be adopted to meet the competition, limits or restriction, promotes production of the goods or provision of services or market, therefore, technical or scientific development. The purpose is that the person should not take advantage of his dominant position, and thereby affect the market. Now, my lord, there is a provision in 19.
Section 19.
My lord. Prior to that, I may take your lordship to, my lord, the 19, my lord. I am sorry. Inquiry into certain agreements or dominant position of enterprises. The Commission may inquire into any alleged contravention of the provisions contained in subsection 1 of section 3 or subsection 1 of section 4, either on its own motion or on receipt of any information in such manner and accompanied by such fee as may prescribe determined by regulation from any person, consumer or association or trade association. First is, my lord, that either commission may by at its own motion or on information received from any consumer, person, consumer or association or trade association, and a reference made by it to the central government or by the state government or a statutory authority. Without prejudice to the provisions contained in subsection 1, the power and functions of the Commission shall include the power and functions specified in subsection 3 and 7. 3 to 7. Now, we'll also make a receive, my lord. The Commission shall, by determining whether an agreement has an appreciable adverse effect on competition under subsection 3, have due regard to all or following factors, namely. So when the allegation is, my lord, with regard to the violation of the effect of section 3, then the Commission has to take into consideration the following factors, which are there, my lord. Creation of barriers to new entrants in the market, driving existing competition out of the market, foreclosing the competition by hindering entry into the market, accrual of benefits to consumers, improvements on production or distribution of the goods or their position or provision or services, promotion of technical, scientific and economic development by the means of the production and distribution of goods or provision of the services. We come to Milord 4. The Commission shall, while inquiring whether an enterprise enjoys a dominant position or not under subsection 4, have due regard to all or on any of the following factors, namely market share of the enterprise, number 2, size and resources of the enterprise, number 3, size and importance of the competitors, economic power of the enterprise including the commercial advantage over competition, vertical integration of the enterprises or the sale or services network of such enterprise, dependence of consumers on the enterprise. These are monopoly or dominant position, whether acquired as a result of any of the statute or by virtue of.
Very well, all the factors are given.
Now, before deciding, because you also have seen section 4 speaks of the dominant position.
How the correct.
So, if somebody is taking advantage
abusing
of the
that
position, then first of all, it has to be determined that that person, company or enterprise is in a dominant position.
The first to consider is whether that company is in a dominant position or not. That is the first inquiry.
Now, to determine whether it is dominant position or not, the Commission must look into all or any of the factors which has been enumerated in subsection 4.
Yes.
Now, the first one is very important.
That is subsection 4. Correct. Correct.
That, like the market share of the enterprise, the size, resources, and all those factors.
Everything is prescribed. How, if an inquiry, either on a suo motu or on an information, how that inquiry is to be made is already given.
So I can say, in other words, that these are the preconditions.
Preconditions, correct.
Which must be fulfilled, or a commission comes to conclusion that any enterprise is taking advantage of its dominant position for creating obstacles in the competition in the market. Without this inquiry being made, the Commission cannot, in my humble submission, my lord, come to a conclusion that there is a violation of section 4 of the Act. Now, this, my lord, 19 is the, my lord, when the information is furnished by some of the complaints that there is a violation of either section 3 or section 4 of the Act. Now we'll also see section 26.
26?
My lord.
Yes.
This is a procedure of inquiry under section 19.
Okay. So this is specifically now how the procedure, what is the procedure to be followed in that inquiry is also laid down.
On receipt of a reference from the central government or the state government or a statutory authority on knowledge or information received under Section 19, if the Commission is of the opinion
there exists a prima
that
facie
there
case.
exists a prima facie case, it shall direct the Director General to cause an investigation to be made in the matter.
Prima facie case has to be made out for an inquiry to be conducted.
Now, prima facie case, when it will be made out?
When there
If
are
there is a
materials
violation
to
of
show
section-
that that the company is in a dominant position.
Section 3 or 4 violation is there, and in case the 4 is there, then whether the dominant position, the company is in dominant position,
has abused.
And in subsection 3, section 3, the various other criteria are there. The Commission has to come to a finding that yes, because of these reasons, I come to a conclusion that the particular enterprise is simply saying, my lord, that there is a adverse effect on the competition. That will not be sufficient, because the conditions, preconditions of section 3 and 4 must be fulfilled prima facie. I'm not saying finally. Prima facie, the Commission must come to a conclusion, yes, these conditions are fulfilled.
The application of mine has to be seen.
And he must come to conclusion, my lord, that on the basis of making inquiry, as per section 17,
this has been violated, so and so has been
prima
violated.
facie, it has come to conclusion that yes, it has been done. Now, my lord, the petitioner after this, my lord, the inquiry will be there. I will come to that later on, my lord. The Director General of Investigation, my lord, he will make inquiries. I will come to that later. My lord, the petitioner is a manufacturer of the cement. And makes a sales and supplies of the cement both within the state as well as outside the state. Now, what happened, my lord?
What is under challenge, Dr. Sarab, in this
You see,
petition?
26
An order of the
by order by which the Commission has directed for an investigation and inquiry under section 26(1). And our contention is that the 26(1) conditions, the inquiry which has been ordered, that is without jurisdiction, unfulfillment of section 3 and 4, without coming to the conclusion that section 3 and 4.
Because in order to initiate that inquiry, there has to first exist a prima facie case. Without a prima facie case in existence, the section 26 inquiry
Prima
cannot.
facie case about, my lord, the existence of the conditions of
section 3 or 4.
And second, our contention is that, my lord, the factors which have been taken into consideration by the Commission
irrelevant consideration
are irrelevant consideration for the purpose of the 3 and 4.
Because 3 and 4 specifies.
My lord.
It's already specifying what is to be considered as violations, correct? So if any of those condition exist, then a prima facie case exists.
And if it comes to conclusion, simply saying that we are prima facie satisfied, that will not be sufficient.
That has to show that which is that particular condition. Is that your case? Because otherwise it will be meaningless. It will be a futile exercise.
It will arbitrary exercise of powers, because anybody can say, my lord, that
their prima facie case exists.
The apex court as well as the other courts have said that this direction of inquiry has a drastic effect on the reputation of the company, and as such it is not simple saying that only we are making inquiry what harm it is caused. That is not so.
No, because the statute says prima facie case has to be.
So I also effect, what is the effect? Because somebody may say, my lord, that, and in fact the Delhi High Court also went to the extent that like in the 482, the quashing is there, then somebody can say that we are making an inquiry, what is the harm? But that is not so. I will place before Lordship all these judgments.
Very well.
Now, information.
You are going to take some time, right, Dr. Saraf?
I know.
You're going to take some time in this matter. Mr. Ahmed, I've seen you've been waiting, and this matter will take some time. If you want to. Very well. You ask your junior to give the item number of your matter. Respondent is also there? All right. Yes.
Assam Real Estate and Enterprise and Infrastructure Developers Association caused a filed an information, I can say complaint, which you'll also find page 43.
Page 43.
My lord.
Yes.
Also find this they filed for violation of section 3 and 4 of the Act.
Page 43, paragraph 10, 11.
43 Miller Annexure 1.
Page 43 of?
Kuntu file, sir. Kuntu first case.
I am holding 6342, Dr. Saraf.
My lord, 6343.
By 3. 6343 to there. Which is that item number, Mr. Das?
52nd item, 51.
It is the main. Penalty no to. Lord, I should have.
It's all right. No problem. This is the first time we are referring to the petition, so no harm. 43.
43.
Yes.
The information lodged by the Assam Real Estate and Infrastructure Developers Association. Also, we find the first in the matter of, that is section 3 and 4 of the violation of 3 and 4 of the.
Yes. Serial number 2.
My lord.
So the complaint is that there is violation of section 3 and 4.
3 and 4.
This complaint is against you.
Against the Stars. There are other cement companies are also there. But
So based on these complaints, the
Commission has taken.
There
are one more complaint. So this is the first one.
Which is the second one?
Second one you'll also
You can just give me the page number. I will just take
61,
a
my lord.
61. All right.
I will also make see. Page 45.
Yes.
Para 2. The respondents above named are 3 dominant cement manufacturers of the northeastern India. Their operations are heavily financed by the government with the taxes paid to by the common citizens.
Yes.
In the form of huge subsidies under the northeastern so-and-so policy. First, my lord, the wrong is that, my lord. They are taking the view that the subsidies which are given under the industrial policy, that means financing the cement companies. Also be aware that the whatever subsidies are given in the industrial policy are incentives or establishment of the industrial units in northeastern region, and there is a distinction between the incentives and financing of the government. There is no financing of the government to the cement companies.
All right.
I will also see the next. The aforesaid subsidies are as under. The subsidies name has been given. Now,
yes.
The combined impact of the subsidies as listed above is estimated to have giving manufacturer a reimbursement of the approximately 150 rupees per bag of the cement. We have filed an ITR application with the industries department to the exact impact of these subsidies per bag of the cement and so and so. So the view has been taken that it approximately comes to 150 rupees, which is given by the government. I will place before lawsuit the judgments that this has no connection. Subsidies which are given are not financed. This is for establishment of the industrial unit in the backward region. Now, the respondent have been leading a rampant syndicate of categorization by controlling and manufacturing the market price of the cement, making it highest in India in spite of the drawing huge subsidies as aforesaid and violating clause 3 and 4 of the Competition Act. Now, perhaps, my lord, the complainant has taken the impression that since these subsidies are not passed over to the customers and thereby they have a dominant and materialistic effect on the adverse competition and violation of 3 and 4. Whereas,
one second.
Milo.
Yes.
As your lordship is aware, the excise exemption which is there, the excise is to be charged from the customers. And after it is charged from the customers, the same is to be paid and it is refunded back.
Can we read this again? This is not clear, Dr. Saraf.
Milo.
Last part. What is that they are trying to say?
What they are trying to say? The combined impact of the subsidies as listed above is estimated to be giving the manufacturer a reimbursement of approximately 150 rupees per bag of the cement. We have filed RTI application with the industry department on the exact impact of these subsidies per bag of cement and bag to leave so and so. The respondents have been leading a rampant syndicate.
But that has not yet been received. The RTI, the information sought under RTI is not received.
Whether it comes to 150 rupees, we take
anyway, but apparently that information has not come.
But assuming it is 100 rupees, assuming it is 125 rupees, the amount is not the consideration. The question is that, what they are saying, the respondents have been leading a rampant syndicate of the quotation by controlling and manipulating the market price of the cement, making it highest in India, of the drawing huge subsidies as aforesaid and violating section 3 and 4 of the Competition Act.
Is this not a little vague? Isn't it vague?
I will not only bear, this is not relevant at all, because the subsidies which are given, that is not the purpose of distributing.
The subsidies are for
the consumption
are
of the
way of incentives to start
industrial unit.
Correct. These
Now,
are those
if that
kind of
subsidy itself is to be given to the customers, then what benefit the industrial unit will have for establishment of the industrial unit in the northeastern region? I place the judgment of the division bench of this honorable court, where in the PVR, the charges, amusement tax which is there, that was charged. And the state says, since you have charged it, you have to pay back. And this honorable court came to the conclusion that no, the scheme is that you charge it and keep it with you. It is not to be passed over to the customers, and that will not amount to an unjust enrichment also, because that is the policy of the government. Now here also, the policy is not that you must pass over. Lordship may remember in the 86 earlier, in the state of Assam itself, the industrial policy was there, that exemption will be there, but you should not charge it. You should not charge at all from the customers. Then only the exemption is there. But from 91, the scheme has changed. And the excise, VAT, everything, the customers have to charge it from the customers and retain it. Like VAT, 100% charging, and 1% has to be paid to the government, 99% is to be retained. So this subsidy has no connection whatsoever in determining whether And secondly, my lord, because the prices are high, that is not one of the conditions of section 3 and 4.
That is what I was trying to see.
That is not at all a condition that it will affect a market. If I charge, my lord, 500 rupees and somebody else is charging 300 rupees, I will be out. But that cannot be said. That has an adverse effect on the competition.
Yes.
In fact, my lord, if I say that if everybody charges the same price, then there will be no competition at all.
But what does subsection 2 of section 4 A1 mean? A2 means?
Well, 4 I will play.
There shall be an abuse of dominant position if a enterprise or a group directly or indirectly imposes unfair or discriminatory price in purchase or sale.
My lord.
What does that mean? That means a fixation of price
My lord.
also can be looked into.
The fixation of the price, if I, being in the dominant position, taking a catechization, that fix the prices of the goods so that the consumer, everyone is selling the goods at the same price. That is because of my dominant position.
That case.
Now, first of all,
whether are you in a dominant position?
Or not. If I am not in a dominant position,
then Section 4 will not be attractive.
Then whether I influence or not, that will not be effective at all, because the prima facie first conclusion must be that
you have to be in a dominant position. All right, noted.
Now, Lordship, kindly see after page 47, I will read, Madam.
Yes.
Based on the artificial price hike affected by tactical agreements between the respondents, the entire market price gets artificially inflated, as even the smaller manufacturers who may or may not be in a cartel soon follow with the price hikes. We enclose here with case memos documenting market price of cement of the three responding companies as of the end of April 16, which clearly demonstrates that the price of all the three companies are exactly the same, that is rupees 360, rupees so and so per bag of 50 kgs. This also documents of a rupees 40 hike in price during the month of August 2016, and that too by exactly the same amount by all the three responding companies. The other smaller companies are now following suit, and similar unfair increases in the market price without any justified reason other than catechization. This has loaded an additional burden of 20% to housing court so and so. So the reason they are citing, my lord, the three cement companies, they hiked the price by 40 rupees. And by that, the other cement companies are thereafter also following the suit and are increasing the prices. Now, similar increase in the prices does not mean catechization. When milk prices are increased, my lord, increased all over the state by one shot.
By one?
By one go. They decide 3 rupees, it is increased by 3 rupees everywhere. But that is not the dominant position. Somebody decides here, I will show that there was no decision at all. But if, assuming, my lord, I increase the price, somebody else comes to know that he is increasing the price, he also increases the price. Nowadays, my lord, nothing is secret. This world, nothing remains secret. One increases, another one will feel that I will increase. Third one will feel I will increase. But only increasing by the three companies cannot mean that
they are in a dominant.
They are in the dominant position, and that will be apparent from the subsequent part, which I will place before Lordship. There are 6, my lord. We beg to bring to the notice of the Commission that the respondents are also transporting their products to distant regions and selling the same goods manufactured in the northeast at a lower price in the neighboring states. They are saying, my lord, that these cement companies are also selling the goods to outside, and they are selling at a lower price. We have collected data from our so-and-so chapters in Siliguri and West Bengal and Patna, among the hordes of other regions, and submit here with some of the figures obtained in the average price of these brands per bag. We have indicated the road distance between so and so. Now they are saying that the prices are like this. The above figures proves that there is a blended categorization of the respondents, as there is neither any impact on adverse transportation cost nor competition between the parties, as they are selling at similar prices in all neighboring areas outside as well as within the northeast. You will also read this paragraph again below. The above figures proves that there is a blanket categorization of the respondent as there is neither any impact on additional transport cost or competition between the parties as they are selling at similar price in the neighboring areas outside in so-and-so. Whereas your lawsuit find in the upper part, he's saying that they are selling at lower price in the other places, whereas they are selling at a higher price in the northeastern region. Here they are saying that they are selling at uniform prices at here as well as outside without taking into consideration the transportation cost. Now they are saying that without taking into consideration the transport cost. Now, the above table demonstrates that in spite of the liberal subsidies, the price of cement has been artificially hiked by these cartels, and the citizens of the part of the country has been flexed by paying highest rates in India. We have recently had a discussion with the Dungsram Cement Corporation Limited of Bhutan, the manufacturer of dragon companies, and they are willing to supply cement at the rate of 215 rupees per application landed cost at Guwahati. This despite of the fact that the government of India does not extend its subsidy to them. It follows therefore from this fact as well as the table above that a legitimate expectation of the people of Assam and Northeastern would be the price not more than approximately rupees 150 of subsidized cements. Now, my Lord, he's saying that somebody in the Bhutan is
ready to give
ready to sell the cement at a much lower price in Assam.
Without being...
Although they are not getting a subsidy. Now, my Lord, what is the competition that a person should not be forced to pay the higher prices? If you can get the cement at lower prices, landed value in the northeastern region from somewhere, whereas my cement which I am selling is a higher price, then there is no force to consumers. Purpose is that the dominant position and he forces the person to purchase the goods at the lower price, a higher price. You yourselves are saying that somebody else is supplying the cement at a lower price in the state. If the person is selling at a lower price, there cannot be any violation of Section 4 of the Act because I am not using my dominant position if assuming it is established for purchasing the cement at the higher rate, because purpose is that, my Lord, that one is forced to purchase the cement at a higher price because of my dominant position, because I control the market. Now here they themselves are saying somebody else
is ready to
sell a lower price, and he's saying that a cement company should sell at 150 rupees. Now, whether I sell my cement at 150 rupees or 250 rupees, my Lord, Section 3 and 4 nowhere says that somebody must sell the cement or something at a particular price.
All right.
Purpose is that the adverse effect on the competition. Now, when somebody is selling at 150 rupees in Assam, and I am selling at 250 rupees, there is no adverse effect on the competition. Adverse effect on the competition means that people have no other option but to purchase the commodity at a prices which have been fixed by the cement companies because of their dominant position.
Mr. Das, you are appearing for whom?
Competition Commission, yeah.
National brands of cement which have already been comprehensively proved to be guilty of categorization, and Your Honour has been pleased to impose a penalty on them after due process of law, are also selling their product in the Northeast. These brands are ACC, Ultratech, Lafrez, Ambuja, etc. are not entitled to any of the subsidy under the so-and-so and have to pay a significant transportation cost as their factories are located in other parts of India. In this context, we bring to your esteemed notice that despite of such difference in the production and transportation cost, the selling price is only marginally higher than the subsidized variety products by the respondents. But here again, similar pricing is noticed from this category. This goes to prove that categorization takes place in various levels, all India as well as regional level, and there is understanding between all India and as well as the local brands prevailing so. They are saying that these companies, although are in outside, but they are selling at a little higher prices in Assam, spite of the transportation cost, and thereby there is a categorization all over the country.
You are selling at prices fixed per bag at?
So this is various, it depends on the
360.
At that time it was relevant, it was
360.
Now the question will come, I place velocity. That this is our selling price.
Yes.
Now we are giving to the retailers and wholesalers various discounts. Now I give 20% discount to a wholesaler. Now normally what happens, my lord, when I give 20% discount, the wholesaler passes the discount without that, passes the discount some portion to the consumers. One person may not pass over. He may sell at 350 rupees itself. One wholesaler may feel that 70 rupees I have got reduction. So 25 rupees I will keep it and 50 rupees I will pass it over. So the sale price cannot be determined on the basis of the per bag of cement fixed by us. Sale price has to be determined on the basis of the amount determined after allowing of the discount. Because that is the sale price, not the price which is fixed. Now I will also make a similar. The next page I will take you also. The Northeast is a notified backward region of India, and the highest cement price illegally enforced by the caterers of the respondents have, besides pleading the consumers, been a severe drain on the national resources, both in terms of subsidy payment as well as the increased cost of infrastructure. This is totally irrelevant for the purpose of Section 3 and 4, wherein they say that the national resources, both in terms of subsidy and increased cost of infrastructure, etc., for the purpose of Section 3 and 4. In fact, they are aggrieved that why subsidy has been given. But in fact, from the entire things, it appears that he is aggrieved mainly that why the subsidy has been given, and if you are getting the subsidy, why that has not been passed over to the customers. Under these circumstances, we beg to make the following humble prayer, and so, imposing a penalty and all those things. And they have, my lord, also annexed some sample copies of the invoices. Also, you can see at page 54.
Yes.
In the between, in between.
Yes.
Cement, tar, topsum, dalmia. Now,
these are the three company names.
Well, I saw that how the fraud has been committed here. Because if I sell a cement, either it must be Star, or it may be Topsum.
Cannot be three.
It cannot, or it may be Dalmia. How it can be all the three companies in one invoice?
These are not subsidiary company. They are all
independent, Lord,
independent company.
Lord. Because the complaint has been lodged against these three, I will show that this is a fraud they have committed. I will show the original voices. And we have taken, my lord, the confirmation of person concerns also, that these words extra have been inserted in the complaint. Now, similarly, you will also see at next page, it says Dalmia cement 360 rupees. So, they have given an example that, and my lord, next you will also see type page at page 58.
Star Cement.
Topsum cement, one bag 360 rupees.
Very well. These are some of the
Examples they are
invoices.
given. These are the examples of the cement sellers outside the state. They want to say that their body is selling the cement. Also may come to page 60.
This is another complaint.
Another complaint by Rajesh Prasad is the Commissioner and Secretary to the Government of India, Assam Industry Department, Food Civil Supplies Department, etc. Also find page 61.
Yes.
The second paragraph,
Yes. That's 3 companies which together have a market share.
My lord. Market companies agreement is contravention so and so. The 3 companies together have a market share of 60% in Assam, have suddenly increased the price of the cement substantially through titration within and corresponding increase of the cost of inputs and so and so. Height of the stable input of supply mismatch. These 3 major cement companies, so and so, Calcum Cement, Dalmia Cement, Topsom Cement, and Star Cement. Now you will also find here. In the first part they were saying about the 3 cement companies. Now it is coming to 4.
Yes.
A brand cement by an amount ranging between 20 to 40 per bag. That the prices were increased from 20 to 40 per bag.
That's double.
No, twice the bag, my lord, you will also see.
Twice the bag.
Increase their prices per bag of the respective brands ranging from 20 to 40, somebody 20, somebody 30, somebody 40 in this way. Clearly indicating that anti-competition agreement and section so and so of the 3 fundamental so and so. Now, the very fact that the increase was not exactly the same. If one cement company is increasing by 20, another is by 30 or 35 or 40. How it can be said that there was a titration,
there was an agreement
to increase the similar prices and for the purpose of anti-competition? I will also see. It may be illustrated by evidence given below with regard to the net sale price of their cement at Guwahati, collected from great difficulties from the companies as well as the dealers, have not cooperated, refusing to give the copies of the bills. Calcon Cement Limited, Balmia, billed a bag of cement for rupees 347. This was increased to 375 per bag on so and so. The details of government price, the movement of the price between so and so has been shown as an Annexure 1. So they say that he was selling at 347 rupees and he increased to 375, means 28 rupees. Topsom Cement, a bag of cement for 325 rupees. This was increased to.
This is how they're substantiating that particular statement. 20 to 40 bags.
Well, I was only submitting that. You'll also see the prices.
They're different.
347 they were selling. The another one was selling 325.
All right, noted.
The third one was selling at 345 earlier.
6.
And 345 has become 366.
366.
The first one, 325, has become 365.
70 has become 400.
And 347 has become 375. So 20 rupees, 30 rupees, or 40 rupees.
All right.
Now 2 submissions are here, they will. The prices of the cement of the 3 companies are not similar.
Yes.
Either the increase, if any, is similar. Only because the 3 companies increased their prices at different dates on the same date cannot lead to the conclusion that they were using their dominant position. Because, my lord, if the cement prices of the 3 companies are different, then there is a competition. If one cement company is selling at 350 rupees, another is selling at 370 rupees, then why I should go with the 370? I can go with 350. Not so that the prices have been fixed in such a way that nobody has that option but to go to this position only. Now,
Earlier it was how much?
look, they are saying
Earlier it was from 325, it has become 365.
347 it was there. They say it will become 375 in one of the companies. Another company they say it was
So that means 20 rupees, 30 rupees, 40 rupees difference.
So it is different in the three different companies, and their prices were also different. Prior to increase, also the prices are different. The first case it was 347, in the second case it was 325, third case it was 345. So it is not that it is a similar one. Now, a market study of whole, next paragraph I am reading, Lord.
Yes.
Of wholesale price prevailing in Siliguri market during the month of August 16 reveals the same bag of Topsem Dalmia cement was available in open market at a much lower price in Siliguri as compared to the prevailing prices in Assam. Moreover, on so-and-so, though the prices in Assam were raised, but the same remained more or less constant. Now, my lord, they have not been able to understand that the company has no control over the prices at which they are selling. He has control over their prices and the discount which is given to the various customers. Medicines are available at 20% discount everywhere now. Somebody is giving 50% discount. Same medicine, somebody is giving 10% discount. Same medicine will be available at 25% discount, 10% discount, and in the shop at the exactly MRP. Now, can it be said that the manufacturer of the medicine is selling in Assam at a higher price but in Bengal at a lower price? No. What is passed over to customers is the discount which they are getting. They are getting 40% discount on medicine. And in way of competition, they are passing over 20% discount.
This phrase is called passing over.
Passing over, Lord. So always you'll also find that they're practicing books. Always below 20% discount was given by the booksellers. How? Somebody was giving 10%. Somebody was not giving at all. Now the price of the books remain the same. But when it is available to the readers, the different prices are there. Because he is sharing his own profit, which is gone by discount, to the customer so that they may purchase it. But that cannot mean that the company is going and selling at a lower price. No. I have explained in my affidavit opposition below the reply to that facts. Now, up to the last but one paragraph, they are saying about the Siliguris. All the three branches, last paragraph, are the manufacturers in Assam, and the manufacturers have been granted mega status, granted so and so. Again, he is saying about the subsidies which they are getting. Next page, 63. It may be noted that these units save 40 to 45 rupees on account of VAT exemption again. Again, my lord, they are saying about the subsidies and the income which is there by way of these subsidies. Next, my lord. To further substantiate our point of view, we would like to submit that the input cost of cement, transportation, electricity, etc. have remained unaltered for the last 6 months to 1 year. Further, in respect of demand-supply issue, the supply is found to be more or equal demand of the state and other parts of India and northeastern region. However, due to local availability of the raw materials and close proximity of the market, the logistic cost for both raw materials and finished goods are also substantially lower for the local cement industries company vis-a-vis the out-of-state manufacturing companies. The local cement manufacturing also reaping the benefit of substantial tax incentives, so and so. So, in fact, from the entire complaint, you will also find crux is that they should charge lower prices because of the various subsidies and benefits and the transportation cost, lower transportation cost. So that they are charging, they are not passing over the benefit of this subsidy to the customer. The whole and crux of the Milord, the complaint.
The complainant is the Commissioner and Secretary.
My Lord.
Food Civil Supply.
My Lord.
It is at his wisdom now the prices to be fixed.
My Lord, I expect Act. First of the Competition Act was not this.
That is true, because if one company is at a dominant position and thereby misuses
Controlling the market.
Controlling the market, and because of that position is misusing its power and fixing the price at a very discriminatory, unfair, because of which now everybody is bound to.
That's the purpose.
That is the purpose.
In fact, the Competition Act says that there should be competition.
By the moment you misuse, that competition stops.
So the competition should be there. Now here, if I am selling at 325 rupees, second is selling at 340 rupees, another is 360 rupees, how it can be said that there was capitalization? Because by an agreement, can one cement company be said that I will charge higher, you charge less? That means his market will be more. People will go for the top sum instead of going for the Dalmia, and Dalmia will instead of going to that one.
Yes.
Now, let me see the order passed by Commission at page.
1 minute.
My Lord.
Yes. Yes, if you have, you want to have water, you please have.
No, it is available. Page 64, my Lord. Order passed by the Commission. Even part at page 66.
Page 66.
66, my Lord.
This is the order under 26.
My Lord.
This order is dated?
No, this is dated
6/12/16.
My Lord. On date. 6/12/2016. Now, Lord, see me. I will take your Lordship to go. First paragraph, my Lord. Second one, Lord, at page 67, that what has been stated in the complaint is mentioned. You will see me come directly to page 68, 2.4.
2.4. Yes.
To substantiate the above allegations, it is submitted. Then again, my Lord, the submissions are there. That the submissions have no meaning. Now, I may come directly to my Lord, page 70.
Yes.
Para 3, my Lord, at page 70.
Para 3.
My Lord.
Yes.
The Commission has produced the information and other materials available on record, besides hearing the informant in reference case number so-and-so on so-and-so. Considering the common OPs and similar allegation in both the matters, the Commission has decided to club both the cases under Section 26(1) of the Act for the purpose of investigation under Section 27(1) Act so and so. The informants appear to be aggrieved by the conduct of the OPs in simultaneously raising the prices of the respective brands of cement in northeastern states in August 2016 without any corresponding increase in the input cost for manufacturing cement and demand supply mismatch in the market cement in the northeastern.
That is their basic allegation. That simultaneous, because coincidentally the increase took place on the very same day. Now, because of that, they are assuming that agreement has entered.
Just a minute. What is the grievance? Is that the prices were increased on the same date without an increase
in the inputs.
In the inputs, demand supply in the market in cement in northeastern states.
Without there being any change in the market, these prices have been increased by 3 companies.
So this is the Commission is saying that this is the grievance. The Commission is saying this is their grievance, that they have increased their prices without there being any increase, substantial increase or change in the product price of the inputs in the northeastern region. Now, if this is taken to be the issue, which was the allegation was there, in my humble submission, by no stretch of imagination, it is covered by Section 3 or 4 of the Act.
Yes, this does not make them...
neither 3 nor 4. Now let us read again further. The informants are aware that even though the OPs are availing huge subsidies under so-and-so reduction northeastern, they are not passing on the benefit to the same to the consumers. Rather, they are charging higher prices per bag of cement for their respective brands compared to the prices at which they are selling the same bag of cements in the neighboring states such as West Bengal, Bihar, and consequently the informants have alleged that the catration by the OPs in the determining their prices of the cement and limiting the production of cement in northeastern parts in contravention of the provisions of the section so and so. The submissions of the informant in support of the allegations of the catration office and the observations of Commission upon the same highlighted below. Observations. OPs simultaneously raised their prices in respective brands of cement in the so-and-so from the sale prices submitted as compared from the tax invoices of OPs during different dates of the months of August. It is observed that on so-and-so OPs have raised the net sale invoice per bag of cement from rupees 345 to 360 rupees. OPs too has raised the net sale price bag per cement.
This is the same thing.
Now, here you will also find
they come to 7.
But the invoices were not raised by us. Where here they are writing a lot. The invoices with the sample copy was there. That is not of ours. That is of the wholesalers and retailers.
Okay.
So the sales invoices which they are annexed, that were not invoices of ours. That is said to be the brand of cement which they are selling.
All right.
Now, OPs are selling cement at lower price in neighboring states compared to the northeastern state. From the cement prices data collected from the so-and-so in Kolkata, Siliguri, Ranchi and Patna as stated in the information, it is observed that OPs are charging higher prices per bag of their respective brands of cement in northeastern states as comparing the cement despite incurring additional cost of so-and-so. The OPs 2 and 3 was to be 310, Siliguri it was 325 and so-and-so. They are saying that at what price it is available in Siliguri. That they are taking into consideration. And that cannot be a factor because first of all their allegation is that that you have increased the prices at a time. Now they are coming that you are selling in the northeast in a higher price, but you are selling in the other states at a lower price. Now whether the Competition Act speaks of a particular locality, it speaks of the particular locality. It doesn't speak of the market in a particular area. a cement company which is selling all over the country, what benefit the company will have to sell the cement at a lower price in Siliguri and not to sell at a lower price here? If I ask a question myself, any businessman or company, whether there is anything wrong with the state of Assam, nothing. Why he should sell a cement at a higher price here and after transportation cost charge a lower price in West Bengal? It's not because of the companies. It is because of the wholesalers and retailers who are passing over the burden of the passing over the discount to the customers. Price differentiation is not because of me. I have not to make a distinction that the price in Assam it will be there, in West Bengal it will be there, and Maharashtra it will be there. If they can show a single paper that the price list of the company was Assam 350 rupees, Bengal 325 rupees, Maharashtra 310 rupees. I will also miss him a lot. From the submission of the information, it is also observed that other major cement companies which are not enjoying the subsidies and incurring additional transport cost and so are selling cement at a marginally higher price in the northeastern region.
Yes.
Now we also see 7. Based on the above observation, the Commission is of the view that there exists a prima facie case and there was a meeting of minds among the OPs to determine the price of cement in the northeastern region. Can you note it, my lord, that the submissions of the whatever were there in the information, right? And thereafter the Commission says that prima facie case is there for meeting of minds to determine the price of cement in the northeastern states.
Paragraph 9.
Paragraph 9. 7. Now I come to 9. 9. In view of the foregoing, the Commission is a primary opinion that OPs by seeking to stifle competition in the market through the above said collusive practice have indulged in anti-competition provision in violation of from Section 3 and 3(1) of the Act.
According to you, these are allegations. Now, whether these allegations prima facie made out a case or not, there has to be some sort of a investigation. I mean, not a full-fledged
not required
hearing, but some prima facie satisfaction has to be arrived.
That amounts to like submission in the somewhere in the judgment, so and so submitted this, so and so submitted. We are of the view.
There has to be also something more reflected in the order, which indicates that the authority has applied its mind to the allegations brought and is prima facie satisfied that a case of investigation is made out. Correct?
They say it is a violation of Section 3(3) and 3(1) of the Act. Now 17 year lawsuit was seen. 17.
Yes.
That for violation of Section 7, 3, what are the inquiries to be made?
That has not, the order doesn't.
Not a single whisper that any of the inquiries have been made.
All right.
In fact, in para 7, directly the Commission says that we have come to a prima facie conclusion.
Is of the opinion.
Then again, the see the 8, again they are writing the same things, that there was a falling trend in the cement prices beginning in from May 16, etc. And then again, it says the OPs are seeking to stifle competition in the market through above so and so. Now, whether they have come up and say that other smaller cement companies, alleged to be smaller cement companies, what were their prices? Whether they were also selling at the same prices? No, not at all. It's not so that because of me, the other cement companies have also started selling at 325 rupees. No. Cement is also available at 275 rupees also.
There, in the market, cement is available for 275.
Other companies, it depends on the companies, my lord. Somebody will go for the better companies, prices will be higher.
But one thing you're right, first prerequisite is that one has to be in a dominant position.
For 4, my lord.
For 4.
He is saying now only
for 3.
3 only. Although the allegation was for 3 and 4, now he's saying, commission is saying 3-3 and 3-1.
What is 3-3?
Let me see 3-3.
Agreement.
Any agreement entered into between enterprises or association of enterprises or person of association of persons between any person and enterprise or practice carried on or decision taken by any association of enterprises or association of persons including cartels engaged in the identical or similar trade and goods or
Prima
provisions.
facie, it appears there cannot be an agreement between 3 separate entities
and
whereby 3 different prices have been fixed. Because you are right, Dr. Saraf, that the other company, why should he sell in a lower price?
Market will be affected.
His market will be affected. He's not a subsidy.
Now he's saying
one could have understood
any agreement. Now agreement means what, my lord? Agreement entered into between the enterprise or association of persons.
And there is nothing to show that these 3 companies are sharing the market.
How much percentage?
That
nothing.
Nothing is there.
Nothing is there. Nor they have shown, commission going to show that other companies, or the cement companies, because of the fixation of prices, the dominant position of mine, that comes to section 4, they are not looking into section 4 at all.
The question that will come for consideration perhaps of this.
Well, I will show to you, Lordship, Lord.
The section
26(1). Well, I will show you, Lordship.
What extent one can go? Because prima facie,
it is an administrative order. But the Supreme Court in one of the judgments has said that 26(1) order, if it is without jurisdiction.
Without jurisdiction, if there is no prima facie. Now, what the question that this court is putting to you, Dr. Saraf, is to what extent one can go to ascertain whether a prima facie case exists or not. That would be also a query. Because you see, the complaint says that on a particular date, 3 different companies
increase the prices.
It may not be at the same price, but there is some increase. And coincidentally, this has happened on one particular day, right? And these 3 companies are dealing with the same, in a similar trade. This, maybe it's a coincidence, but this is done. Now, definitely there is nothing to show that there is some agreement between the 3 companies or that there is an agreement to indicate that they are sharing the market. Those are not there. But how will one ascertain this at the stage of 26?
I will submit. If the commission, without following the procedure, without making the necessary inquiries, is expected of the commission, or coming to the finding about section 26(1),
yes,
then in my humble submission, my lord, the action of the commission will be totally against the provisions which are there in the statute. Because if a particular procedure is laid down, my lord, for making an inquiry and coming to the conclusion.
Dr. Saraf, that procedure is in regards to the dominant position,
No,
right?
3 also, my lord.
3 also, where
My lord, section 17(1).
And
18, my lord.
Of commission.
18, you'll ask me, see, I'm sorry, my lord, duties of the commission.
That part you have not shown because 19 talks about dominant.
No, 19 not.
And
19 is the 93, my lord, 93.
Correct. So this inquiry has to be also done. Now it appears from the complaint itself then another party is ready. That party from Bhutan is ready. So therefore, prima facie, you are not creating a barrier.
My lord. And also, my lord, if other cement companies...
So these inquiries has to be done. Now without doing these inquiries straight away, you cannot say there is a prima facie case. This is what is your submission in short, right, Dr. Saraf? That to come into the, in order to come to a prima facie satisfaction, the inquiry as stipulated under section 19 has to be done, which apparently on the face of the order has not been done. This is one limb of your argument.
Secondly,
yes, please.
That if other cement companies are following my suit,
are following
my whatever is there, my agreement and etc., they are also selling at the same prices, then there may be a violation of section 3 of the Act. No inquiry has been made at what prices the other companies are selling the cement in the northeastern region. Because the purpose is that, my lord, by making an agreement, a cartel is created. Cartel, when it will be created, my lord, not 3. If there are 8, the 3 cannot be, my lord, have a cartel. In the bidding process, my lord, cartel when it is created, the 3 bidders all they join together. If out of 5, 3 join together, 2 are left out, then where is the cartel? Cartel will be only when all they become in one agreement, and thereby they rig the bid.
Right.
Similarly, in the case of when I say that the cartel is there, they are doing everything to influence the market. How the market has been influenced? How the market has been influenced? You say that I will purchase Topsum cement also, and you sell it at the prices at which somebody else is selling. No. The different brands, the different prices are there, higher prices, lower prices, that is the competition. Nowadays, my lord, the same thing, the same pain is available at 100 rupees also. When we go for the Mont Blanc, it's 20,000 rupees.
Quality.
There is nothing. Quality also not there. Quality
brand.
also, according to me, is not there.
And the brand.
It's brand. That I am satisfied that yes, I go for the Mont Blanc. But that doesn't mean that Mont Blanc will have to also sell it at 150 rupees. Then what will remain? I was purchasing shoes at 900, 1,000 only. 20,000 shoes are also available. Those people who are wearing must be feeling some comfort. They are purchasing it. Can it be said that no, when 1,000 rupees is available, why you will sell it at 20,000 rupees?
All right.
So, my lord, the scope of inquiry, I fully agree with Lordship. In 482, when prima facie on the basis of the documents and papers which, although recently the Supreme Court has said not only papers and documents, can go for further inquiry.
But in that case, a caveat is also given that is only in the facts of that particular case.
That is the only judgment.
Which actually goes to that far.
Otherwise, from the beginning to the now.
Yes, because in that judgment, one thing has very nicely been said, because in today's world, the lawyers are very smart. So once they draft the FIR, the ingredients are put. So as tomorrow...
Everywhere, everything will be written there.
Yes.
So now, earlier, whatever there, you show FIR, their case is made out, dismissed. Now the things have changed. So now the scope of inquiry has become much wider.
Yes.
Now here, if somebody writes that same language of the section, that will not be sufficient. The commission tomorrow writes the exact section. Say that yes.
Dr. Saraf, I am not on that, but I was wondering to what extent one can see, but the answer is in section 19. Section 19 makes it clear what is the how the inquiry is to be done. Now 26
Not only inquiry, my lord.
Because 26,
when we say prima facie
26
case,
says on receipt of so and so under section.
It says, my lord, about the knowledge so and so prima facie case, my lord. There exists a prima facie case.
Still, one thing is not clear whether the prima facie case is a prerequisite for inquiry or not.
Prerequisite for directing an inquiry.
Inquiry or not. And in that, and whether section 19 procedure has to be followed.
On receipt of the reference from the central government or state government or authority or on own knowledge, so and so,
or information received
under section 19. 19 information is there, then 2, 3.
In this case, there are two complaints.
That is 19, 19.1.
1. What does a reference made mean? The reference is made under section 26? No. What
26.1, my lord, the direction issued for making inquiry.
Inquiry by the Director General. That inquiry is not section 19 inquiry.
No. 19 inquiry, if your lordship says true again, once again, lord.
Yes. Yes.
Without prejudice to the provisions contained in subsection 1, the powers and functions of the Commission shall include the powers and functions specified in subsection 3 and 7. 3 to 7. Now 3 says the Commission shall while determining whether an agreement has appreciable so and so, it is mandatory. It doesn't say the Commission may.
All right.
Commission shall have to consider all or any one of the factors.
But here, prima facie, it appears that the satisfaction that is prerequisite in under section 26 depends on the outcome of the inquiry that the Commission will undertake under section 19. And what is the scope and ambit of that inquiry is already provided in subsection 3 as far section 3 is related. And as far as 4 is related, that is, I think, subsection 4. Subsection 4. So the parameters are laid down that this is how, and if suppose this inquiry is done, a report is given which indicates that one or two of the parameters that the company is creating a barrier to the new entrants in the market, if those things are there, then prima facie satisfaction can be generated. Correct?
In this case, you'll also find the Commission
that is not there.
Any inquiry.
That is not there. Prima
Commission
facie
simply bases that what has been
alleged
in the complaint.
Correct. The prima facie satisfaction is in terms of the allegations. Whether the allegations are correct, not correct, that exercise has not been done.
When we say the 202 CRPC, inquiry is to be made. Now, without inquiry, somebody has issued summons, all are passed. That inquiry has not been made.
Yes, that is. In fact, Bhajanlal also says before registration of an FIR, the police should not be automatically registered. Some satisfaction has to be there.
And in these cases, which has a far-reaching consequences, one cannot, and the Commission what he says, the prima facie case, you'll also, once again, for the sake of repetition, also 26.1, Miller.
Yes.
If the Commission is of the opinion that there exists a prima facie case,
that is condition precedent.
It shall direct Director General to make investigation so and so. So, prima facie case about what? Violation of section 3.3 and 3.1.
This
3.3 and 3.1.
The impugned order is on the basis of the they have been filed under section 19.1A and 19.1B.
Well, that is the 19.1B is there because the government is there, and 19.1A because the private one is there.
Inquiry is not there. There has been no inquiry.
No. They filed a complaint and it was taken up.
Commission which is referred in section 3 of section 19 is which commission?
This Competition Commission, Lord.
Competition Commission. All right.
You'll also find the section 2E, Commission means the Competition Commission.
E?
2E.
But this, which is they are saying they have received under 19.1.
19.1A, my lord, is the about private person.
Private person, correct.
And B is the, my lord, the government. So first was the real estate, in this one private
So
one.
there were two complaints, one from the private and the other one was that commissioner.
Government.
So complaints were.
My lord.
It appears that these complaints without inquiry was forwarded and the order
It was submitted to the commission.
to the commission and,
And commission
without
not
any,
made an inquiry.
without inquiries straight away order under 26 was filed.
My lord.
It appears that like
No
that.
inquiry is made. because
Unless we are yet to hear the
No, you'll also may see in the order
computing
itself.
authorities.
In the order itself, you'll also find.
You're right, but nonetheless,
My lord, yes, certainly, my lord, if they have
I
got
have to
something.
hear both sides.
100%, my lord.
On the face of it, Dr. Saraf, you're right.
My lord, may kindly see, my
The
lord,
order doesn't speak of any inquiry.
page 74.
Or yes,
This is, my lord, the direction of the Director General. And you'll also find that this order,
this is after the after that order.
I only want to place, my lord, that the date,
So this consequential order must be also under challenge.
is also challenged.
Challenged.
You'll also see the date 6/8/12/2017.
Where? Where?
The top page 74.
See, it's 8/12/17.
My lord.
8/12.
After 1 year of the passing of the order.
6/12/16.
And I will place before also the judgment of the Apex Court which says it must be done within 60 days.
Exactly after 1 year.
My lord. Now, my lord, I came to know about the order only after receipt of this intimation from the Director General. But the order of 26(1) is not served on us.
Therefore, some delay.
Now, thereafter, I filed a petition before the Commission for review or recalling of the order.
July 18.
My lord, it is 31st July 18, and I will take your lordship, my lord, to
the review order.
My lord, no, I will first of all take your lordship to my submissions. I filed a written submission, my lord.
Yes.
The first part is that the power of the Commission to make a review. Recall.
Page 84.
My lord, page 84.
That I don't think is relevant.
My lord, it will be relevant for some context, my lord. I will show to your lordship, my lord. You'll also see page 86.
The difficulty is everything is fresh in the mind of the court now, but
it will remain fresh there, lordship. You'll also see page 86, my lord.
Holidays are coming, and thereafter, as indicated,
Lord,
this court will also not be available.
The basic issue, your lordship will got it there. Rest are page 86, my lord. Only thing that 2.
Yes.
The informants have forged, misleading and fabricated evidence in the information against Star Cement, more specifically the tax invoices and case memos at so-and-so submitted by the informant number so-and-so. For instance, the invoice issued by so-and-so, limited page number so-and-so, is forged as informant has added, stating that the invoice relates to
This
the
is
sale.
what you had already submitted. The
No, I am submitting, Lord,
three
that this was-
companies that were put together.
I am only submitting, Lord, that this was placed before the Commission, that a forged or forgery has been done.
Invoice.
Your Lordship is not aware when the fraud is there, that vitiates everything, then nothing, the court will not go into anything when
This
somebody
aspect
joined
also the
project.
commission did not, they did not take
My lord,
note of.
the will also miss further see, my lord. I will just take it also, my lord, that relevant
Yes,
part,
yes.
my lord. My lord, at page 91. Or prior to that, my lord, effective price which I mentioned, my lord, the submission which I was making before lordship, at page 87, my lord, for the time being, my lord.
Yes.
There are 2.6. That is the well-known industrial price is that the effective price of the cement offered by a cement manufacturer, including Star Cement, depends on the discounts that are offered above the invoice prices. These discounts are offered by the cement company dealers and not to the end consumers. Based on a dealer's performance, rewards are also offered to the form of cash discount rate so and so. Thereafter, given below various judgments of the apex court, wherein it has been said that it will be the effective price will be only after allowing of the discount. Now we'll also can see at page 90. During August 2016, the period considered by the Commission on the impugned order, Star Cement allowed discount to the range of 8 to 35 by way of credit notes, discounts with effective prices ranging from 301 to 356 and not from 345 to 366 as alleged by the informant 2. The effective prices therefore range between 301 to 330 from so-and-so to so-and-so and in the range of 331 to 356 from so-and-so. The market survey of August 2016 prices charged by the Topsem and Dalmia would show that there was no price parallelism between the OP's number informant 2 had presented the invoice prices and over simplistic manner with a malafide and inferior motive. Similarly, such mistaken reliance on the deliberately misleading data submitted by the informant led to the Honorable Commission to survey of so-and-so. Thereafter, my lord, in the page 91, I have given the effect of the subsidies. My lord, subsidies in North East do not confer an advantage to cement manufacturers as subsidies are there to support the viability of the cement manufacturing business in North East. The North Eastern region so-and-so. Thereafter, also may see in the middle, my lord, I have given the judgment of this Honorable Court Division Bench. The Guwahati High Court was dealing with
PVR
the
case which you were referring to.
My lord.
What was the facts of this case?
My lord, there the PVR, various PVRs were exempted from payment of the amusement tax.
Amusement tax.
Now, the PVRs charged the amusement tax but has not paid. The state government says that since you have charged, that must be paid. Otherwise, you have unjust arrangement. This Honorable Court said no. This is not the basic. You may just see, my lord.
Yes.
In the quotation portion, para 45.
Yes.
As earlier noted, the charge and levy to tax was never examined, and therefore the sign goers were not provided any relief under the exemption notification. On the other hand, the exhibitor was freed their obligation from the liability of entertainment tax, though the notification issued under Section 9(2) of the Assam Act. Though we have no hesitation to hold, therefore hold that the incentives were intending for the investors on cinematographers, and consequently for the limit period, the exhibitors can't be forced to discharge their obligation under Section 3(6) of the Assam Act, since the present case entertainment tax has been levied only on the ground that in spite of the exemption being granted by the notification, petitioners illegally collected entertainment tax, the impugned orders of assessment are declared illegal without jurisdiction and so and so.
Dr. Saraf, this is of course on the merit. Suppose this court comes to a finding that the inquiry stipulated in section 90 and the prima facie satisfaction is no satisfaction at all. And in that count 26 is not fulfilled, the mandatory condition, and therefore that order is met. Then this court need not go into the merit. I'm otherwise saying.
I am only trying to convince that even these judgments were placed before the Commission.
Commission ought to have taken.
And the Commission, when Milord dear Lordship is aware, when the judgments of the apex court and the division bench of this honorable court is placed before the Commission cannot, because in the review order subsequently, they said that there are other factors are also there. So we will not go into the fraud and all those things. There were other materials were also there. Now simply other materials were there. What were the materials? In 26(1) order, the commission order you'll also find.
But when before this court, the Computation Authority's order itself is open, isn't it?
My lord.
So this court can confine.
Look, our purpose is the 26(1) order is contrary to the provision section 3.
That's right. So if this court holds that, then your purpose is served.
My lord.
I'm only. Of course, you will argue on all the aspects because
my lord.
Tomorrow what happens nobody knows. But I'm just generally saying that. The purpose of showing this is that these are the ground submissions which you made before the reviewing authority. The reviewing authority has not considered any all of them. What is this ACC Ultratech that you are mentioning at paragraph 10 of that review petition at page 93? Paragraph 9. Okay, these are that Lafarge and all.
Of submissions were made.
No, where you are just reading, page 93.
93.
Page 93, paragraph 9.
9, my lord. However, it is evident, 9, my lord.
Yes.
It is further submitted the states outside Northeast region also offer subsidy to cement manufacturers. West Bengal also run on an incentive scheme for cement manufacturers which is applicable in other cement companies. So we are saying that it is not so that in other states the incentives are not there. And moreover, it is evident that the press release dated so-and-so that even the price of ACC Ultra were also hiked by rupees 1540 on so-and-so date.
Yes. Order otherwise is at page 97.
I know. Yes. To be a copy. You can see a page 593, paragraph 114B.
This is on what point?
On the power of the 226.
Section?
100, para 114B. Page number 593 at the bottom you also find.
593. Yes.
Come to me, Lord. The other discussion is there. Page 117, para 117. Middle, my lord.
Yes.
I was saying, like, even if the order is administrative in nature, the question raised before the High Court in the writ petition filed by the respondent touch upon the very jurisdiction of CCI. As is evident, the case set up by the respondent by the CCI did not have the jurisdiction to entertain any such request or information was furnished by the so-and-so others. The question thus perceived to the jurisdiction of CCI to deal with the matter, and in the process, the High Court was called upon to decide as to whether the jurisdiction of the CCI entirely excluded or to what extent the CCI can exercise the jurisdiction in these cases where the matter could be dealt by so-and-so. And you'll also be aware the judgments in the latter part, you'll also may see in the next page, at the bottom. It is thus clear that the presumption of jurisdiction by court or tribunal, existence of the jurisdictional fact.
Where?
At the bottom, page 3, paragraph 117 and 595 in the middle, you'll also find.
Yes. It is thus clear that
fact that we also see para 27 started.
Yes. Stated
simply the facts upon which the jurisdiction of a court, tribunal, or authority depends can be said to be a jurisdictional fact. If the jurisdiction of fact exists, a court or tribunal jurisdiction to decide other issues. If such fact does not exist, a court or tribunal or authority cannot act. It is also well settled that a court or tribunal cannot wrongly assume existence of jurisdictional facts and proceed to decide the matter. The underlying principle is that by erroneously assuming exercise of jurisdiction in fact, a subordinate court or inferior court cannot confer upon its jurisdiction which otherwise does not possess. And the last paragraph, my lord, it is thus clear that for assumption of the jurisdiction by court or tribunal, existence of the jurisdictional fact is a condition precedent. But once such jurisdictional fact is found to exist, the court or tribunal has the power to so and so. First of all, the jurisdictional fact which is there in section 3331 read with section 19.3 must exist. And here the court is saying now that the writ petition will lie. Also, see next page, my lord. Thus, even when we do not agree with the approach of the High Court in leveling the impugned order as quasi-judicial order and assuming jurisdiction to entertain the writ petition on that basis, on our own and different regions, we find that the High Court was competent to deal with decide the issues, so and so. The court said it is a quasi-judicial order. The Supreme Court said not quasi-judicial order for administrative order, but the High Court was justified in entertaining the writ petition.
Yes.
Many cases you'll also find in other cases, the court has said that 26(1) order is there, the court should not intervene. But speaking of a detailed order, the court has said, yes, 26(1) order is an administrative order. But judicial review of the administrative action is always vested in your clauses. So one cannot say that because it is administrative order, the court should not look into it at all. There are other judgments and all those things.
Administrative order and it affects your rights.
My lord, administrative order, if it is made to depend on the certain situations and certain jurisdictional facts, then that must exist. Without that, it cannot be.
And a manner has been prescribed in which how it has to be performed.
My lord, under Income Tax Act 148 notice is issued. Reasons to believe. The court always asks for the reasons and examines that whether these reasons are sufficiency of the reasons you will not go into.
Absolutely, but there has to be some reasons.
But the reasons must be there which has a nexus with the belief which has been formed. If there are no reasons, in my humble submission, it is not to speak of the administrative order or quasi order. If the order lacks the reasons for coming to a prima facie conclusion, that order cannot stand.
As the authorities file their affidavit,
they file.
What is their stand? What is the stand in their affidavit?
My lord, mainly their stand is that, my lord, 226 petition will not lie.
Maintainability.
226 petition under 26.
Because it is purely an administrative order.
Purely, my lord, the starting point inquiry only, nothing. Inquiry will be held, everything will be held. Thereafter, all hearing will be given. After only the final order will pass.
Any authorities on 26? Any authorities?
Well, I have given this authority of Supreme Court.
Any other authorities besides?
Well, other authorities, my lord, the Delhi High Court is there. Normally, when we say, my lord, in 482 also, or 226 also, we can file for quashing. Normal court says your lawsuit will not entertain. But if I say, my lord, that something has been done without jurisdiction or without following the mandatory conditions or assumption of the jurisdiction, and when the section says prima facie case exists, prima facie case can be existed only when the commission comes to conclusion after making the inquiry as per section 19(2), 3 and 4, and if the conditions of section 3 and 3(1) are fulfilled, 3(3) fulfilled. Now, in what manner it has been fulfilled? Nobody knows.
In the affidavit, anything said about inquiry?
So I don't think so. There anything affidavit they have said about the inquiry.
Mr. Das, have the inquiry contemplated under Section 19 has been done or not done?
So, Your Honor, it's not required.
It is the stay, my lord. There is a stay.
There's a stay in the proceedings. But in my respectful submission, the inquiry is only required once 27 gets triggered.
All right, we'll hear you today.
Yet, my lord, I will place 2 or 3 judgments.
Yes, yes, there is time. Yes.
Thereafter, my lord, in the next case, in fact, a penalty has been imposed for 5 lakhs.
Cases.
Yes, next writ petition. Item 50.
Yes.
A case of imposition of penalty of 5 lakhs for not furnishing the information to the Director General of Investigations. We have said that whatever information I will show to your lordship, whatever information was sought for were always furnished. Time was sought for, time was granted. Now, once the time is granted,
what is that? 6342?
My lord, 64.
Matter was earlier heard by some bench.
No, this twice, my lord. One first, my lord, the judgment was reserved by Justice Deka.
I see there is a note.
About 3 days, my lord, it was heard, and the was reserved. Thereafter, because of then it went to my lord Justice S.K. Mehdi. Number of days, I think it was heard. And again, because nowadays 3 months after that, better even hasn't been parted. Then again, it went, my lord, it has moved to every court. Ultimately reached to your lordship, my lord. Final destination.
Fully, we can pass the judgment before 3 months. So the difficulty is the availability of this bench also.
That is the main difficulty with stenographers.
After holidays are starting and then
Lord, the stenographers are not good, then making corrections, it makes horrible.
Very difficult. Anyway,
Lord, those persons who come from the bar are habituated of that, everything corrected, we just make
is
some
the trouble, Mr. Dr.
Now we are
Saraf?
doing everything, comma, full stop, and
assistance.
It's horrible.
And
I was wondering that,
scarcity of stenographers.
I was wondering that, my lord, how the person who goes from the bar and to the bench, how he tolerates this dictation part and correction part.
Big challenge, Dr. Saraf.
Next to impossible. Or see, we have to check up all conclusion port pass, because otherwise what will be dictated and what will come, nobody knows.
I think it would be, what we can do is, we can have this matter posted on, your part is over, right?
Lord, I will place 2-3 judgments more, my lord.
You can place it and also maybe a written argument that will
and
be
of penalty part, my lord, only half an hour I will finish it up.
On 19th? Because from 22nd this code will not be available.
No, my lord, 19, my lord,
19th at 2 o'clock?
19, please, yeah.
At 2 p.m. But an endeavor should be made to finish it, because then
it will not take more than half an hour.
I will not take 15-20 minutes.
I'll have to carry the file and join through VC.
My lord, and also in the meantime I will prepare the written submission.
Yes. If
both
you
the
want
bills
to
also
give it, whatever written argument you want to give, and whatever authorities you want to cite. Bhargav, to me likhi lo. Third in part, based on 19/4/2024.
At 2 p.m.
At 2 p.m.